Hi friends, good morning. Welcome to Insights IAS. Today we are here to discuss the General Studies Paper 2 of Mains 2025. Today we are having Manjunath Sir, who is a faculty of Polity and Public Administration at Insights IAS, and myself Shashank, a faculty of Political Science, International Relations and Internal Security. So today let us start with the discussion of the current Mains 2025 GS2 paper with the analysis to see what exactly are the changes from the previous year. Is there any change of pattern? A lot of students have told that paper was kindly not exactly how it was in the previous year. So let us ask Manjunath sir what is his opinion about this year's GS2 paper.
Yes. Actually, if you look at the 2025 GS2 paper also, with respect to the marks distribution, it is more or less the same. Both polity, governance, social justice, international relation, marks wise, it has not changed drastically even from the last 10 years. So it has more or less remained the same. But what has changed is the questions look actually more analytical compared to last year's. They have not, even though the themes are more or less the same, the way they have drafted the questions is not so easy to decode the demand of the question in the real-time exam and then construct the answer, structure it, and then generate dimensions is not exactly easy. So probably those who would have managed to decode the overall demand of the question and structure it broadly and generate dimensions, rather than trying to write perfect answer, they would have managed it very, very well yesterday in the GS2 paper.
All right, sir. That was a nice analysis of this year's paper. Yes, paper was easy if you just see the topics, but again to decode and write answers within 3 hours is the biggest challenge.
Exactly.
And especially governance questions were a little complicated. But again, how do you decode the question, analyze the demand and put it on paper is the biggest challenge. So in this session, we are going to discuss all the 20 questions. Just try to decode what exactly is the demand of the question and how are we going to structure the answers.
Correct.
So let us start from the first question. That is about Representation of People's Act. Again, one more thing that I want to tell you is the type of questions that come in your exam. It is of two types. One is directly current affairs question which are picked up and asked. Examples are Jammu and Kashmir Legislative Assembly, the pardoning power of the president which was in the news, and again anti-globalization movement that is happening across the world. So these are questions that have been directly picked up from the current affairs. While static parts, for example, if you observe, judiciary should be asked, judicial accountability, a question has been asked, and one more was about judiciary and the Collegium system evolution. Straightforward, and fiscal federalism was in the news, directly asked the evolution of fiscal federalism. All right. So again, students who are preparing next year, be prepared for this. Read the current affairs of the last 1 or 2 years. At the same time, be ready with the static part. So starting with the first question about Representation of People's Act. I'll be reading the question and Manjunath sir will be helping us decode what exactly is the demand of the question, even though we'll not be going in detail with every answer because it's going to take a lot of time. Discuss the corrupt practices for the purpose of RPA 1951. Analyze whether the increase in the assets of the legislators and or their associates disproportionate to their known source of income would constitute undue influence and consequently a corrupt practice. A 10 marker.
Now, let's look at the subparts of the question. So, first question is what? Discuss the corrupt practices. So, that you need to identify that you need to make it as a subpart 1. Second subpart, what it says is that if in case they have made assets which is disproportionate to their income, can we consider it as a corrupt practice? That's the second part. So, first what we need to mention is that Section 123 Act of RP Act 1951 talks about so-called corrupt practices, broadly what it includes. So, we'll not get into the details. Broadly, it includes, for example, what you call as any kind of undue influence, which includes threat to the people, threat to the opposition candidates, bribery, references to religion, caste angle, or for example, what you call as this misuse of like government officers or the people in power misusing their resources.
Appeal to religion
like that.
and caste,
Exactly.
etc.
So, there's a list of it. That is your corrupt practices. That's first part you should have mentioned.
So this carries around 5 marks.
5 marks. That probably you can say first side of the answer you can mention about it. Then the second side, what you have to talk about is subpart 2. If in case there is an increase in their assets which is disproportionate to their income, do you think it will fall under undue influence and thereby a corrupt practice? Now, for that, if you mention it in simple terms as a conclusion statement, also if you mention, actually RP Act 1951 does not mention anything like this explicitly. So, the question that itself they are asking, do you think it might lead to undue influence? Yeah, maybe you can consider when they make assets which is disproportionate to their income, if they try to use the disproportionate assets either to bribe the voters, either for some other corrupt practices, either to threaten the voters, then you can consider it as undue influence. Directly, just because they have made disproportionate assets, you cannot consider as an undue influence, again, unless either Parliament should amend RP Act and mention that, or Supreme Court should clarify that in one of their judgment.
Rather, the disproportionate income will actually fall under Prevention of Corruption Act.
That issues, you can deal it under Prevention of Corruption Act, Benami transaction issue, or some other, let's say, Lokayukta, Lokpal issues can deal with it. Directly, you cannot consider it as an undue influence unless the candidate is misusing it either for bribery or threat or some other issues. That you have to prove it with evidence in the court, or Supreme Court should give the judgment, or Parliament should amend that and mention it under RPR.
All right. So basically, in this question, I needed to know about what exactly is corrupt practice. Exactly. 4 to 5 problems.
Section
123. And those 4 to 5 sub-points we discussed: bribery, undue influence, etc. And the second part is again a little analytical part where we have to say whether it actually is undue influence or not. That is going to be our opinion. Okay, sir. Moving on to the next question. Comment on the need for administrative tribunals as compared to the court system. Assess the impact of the recent tribunal reforms through rationalization of tribunals made in 2021. Again, two demands in the question. Directly 5 marks for this. The first part, that is the need for administrative tribunals, that is advantages. And second one is the impact of the recent rationalization of tribunals in 2021.
Okay, fine. So in the introduction part, what we have to mention is tribunals are, what we need to mention is that they are quasi-judicial bodies. So they have been given a constitutional status in Part 14A, and then they are mentioned in Article 323A, which is administrative tribunal, 323B, tribunals on other matters. And then if in case they can also mention about 42nd Amendment 1976 added it, and Swaran Singh Committee. In the introduction, it is better you mention these constitution related facts because it's a polity question and evaluator will be expecting. So keywords: Part 14A, 323 Administrative Tribunal, 323B Tribunals and other matters, 42nd Amendment, Swaran Singh Committee. Then you come to the first demand. What they are telling: comment on the need for tribunals compared to court system. This is not exactly like a kind of, it's a combination of difference, but the keyword is need. Why do you think a need for tribunals? Obviously, there what you can tell is that it's a kind of, maybe you can mention it as a kind of tabular column also, and you can mention it. Normally what happens, courts follow very, very rigid procedures. It takes a lot of times. They follow CPC, IRPC, CPC, CRPC, IPC. Obviously, for witness, evidence, for all those things, procedures are very complicated. It takes a lot of time. Judicial cost is also high, and the judicial verdicts will take too much of time. As they famously criticize in judiciary, process itself is a punishment. So that's the reason we need tribunals. Obviously, what is the advantages? Judicial cost is less, flexible procedures, and then the
technical know-how.
Technical know-how, specializations will be there because like income tax tribunal will only look into that issue like that, or administrative tribunal like CAT, SAT, they'll only look into the issues related to the service conditions of mostly the civil servants. And obviously, they follow principles of natural justice. That's why it is quick to resolve the cases. That is the need for tribunals. Automatically, what will happen, if they want to extend, they can tell that it will reduce burden on the judiciary because they are already overburdened by more than 4.7 crore cases. All those you can add. That's your first part, need for tribunal. Second is impact. That's a keyword. Impact of the recent tribunal reforms through rationalization of tribunals. Actually, 2021, Government of India brought through an ordinance rationalization of tribunals. But there was some issue, Supreme Court tried to struck off few provisions, then later they amended it again. But core point, what do you mean by this rationalization of tribunals? So some 3-4 major points are there, they could have explained it. Like for example, first major is they have gone for merger of few tribunals. Merger, or you can say kind of abolition also. The need was because there were too many tribunals, tribunalization, what they call it as, too many tribunals were there, overlapping issues were there. Like for example, film certification appellate tribunal was there. Now they have abolished it and they have told any issues, you go directly to High Court. Okay. And another controversy was there that the service conditions, appointments are very different for multiple tribunals. That's why what they have tried, standardization, uniformity. More or less what they have told is that the term will be 4 years, maximum age is 70 years, eligibility, minimum age is 50 years. And Government of India will have major control on the making rules related to all these service conditions, something like that they have made. Now they have told impact. Obviously, like any serious aspirant will be knowing, you have to write positive impact, negative impact. because it's a 10 marker. Even if you write 3 each, it's more than enough because you would have already addressed the first one. Advantages will be overlapping, all those issues you can address, it's standardized now, efficiency will increase. Those are obvious points. Negative is what, as Supreme Court told in Madras Bar Association case, that independence will be compromised. Government of India will get direct control. There will be conflict of interest, bias, all those issues you need to write. So as a conclusion, you have to write the tribunals have a very huge, have a very huge role to play in India because it will reduce the judicial burden, reduce the judicial cost. However, rationalization of tribunals should not lead to compromising its independence, because they are also more or less equitable. As Supreme Court, one of the case, Chandra Kumar case, had told that they are more or less equivalent to high courts. Yeah, their independence should not be compromised. Yeah, that's it.
All right, sir, that was a comprehensive discussion about the second question, that was the need for administrative tribunals. Again, to summarize, we need to address two parts. One is the need for administrative tribunals. Again, how do I add value to my answer? Or a lot of students ask, sir, how do I make my answers more attractive? How do I get good marks? Just by writing specific parts, part 14A of the Constitution, Swaran Singh Committee recommendations, and 42nd Amendment. As soon as the examiner reads this, he gets a very good idea that this person knows the answer.
Keywords matter a lot.
Yes. Okay, so let us move to the third question. Again, two questions are actually merged here. One is comparison of Indian constitution with other constitution, and also role of legislature executive, where the question is on compare and contrast the president's power to pardon in India and in the USA. Are there any limits to it in both the countries? What are preemptive pardons? Again, so three parts in this question. So again, please have an idea that you have 2 sheets to write. So if I'm going to write 3 subparts, please give equal spacing for everything.
Correct.
You can't write one part for 1.5 pages and address the other 2 parts. That is when you are not going to get marks.
Yes.
All right. So why was this asked? This was asked because as soon as there was a change of government with Republicans and Donald Trump coming to power in USA, the previous government under Joe Biden, especially President Joe Biden, passed a lot of pardoning orders to himself, his family, and the very close aides. So this led to the asking of this question. Yes, sir.
Okay, fine. And now, obviously, if you look at the question, as you already explained, the question is related to the pardoning powers of the president. With respect to it's a kind of related to the question of, as you told, comparison of Indian constitution with that of other countries, comparing president's power in India and US. Obviously, so you can start in introduction talking about Article 72, pardoning power for India's president. Maybe there's not necessary. They could have also mentioned about Article 161 gives the similar powers for the governors. Obviously, in Indian context, pardoning power is for obviously what aspect? One is president can pardon with respect to any sentences under union law. Second one is with respect to the martial code. Third one is any kind of death sentences. Now, under US, and again, normally what the word they use is called as clemency powers is what normally the word they use in US, and which we normally don't discuss, but it is under Article 2, Section 2 of US Constitution. It talks about clemency powers of the US president. Fine. Now, what are the differences? Like as we told, in India, it is with respect to union law. Like in US also, it is with respect to the federal law. In India, obviously, compared to the US president, in India, relatively checks and balances is more. As the second part says, what is those checks and balances? First, in India, president pardoning power is not the discretionary power of president. Supreme Court has clearly told that. It is based on the aid and advice of Council of Ministers. If in case they remember, the students could have mentioned about Maru Ram case, in which Supreme Court told it is not a discretionary power, it is aid and advice of COM. 3. It is also subjected to judicial review in India, which is, again, if they remember the case, they could have mentioned Ipuru Sudhakar case. President's pardoning power subjected to judicial review, and as if it is arbitrary. Fine. But in the US, what will happen? It is purely a discretion of US president. So there is no, because obviously they follow presidential system, it's a purely discretion. Judicial review does not apply. So in other words, compared to India, US president's pardoning power are more broader. Fine. Again, but as a limitation, if they want to mention, they can tell that in US, impeachment issues cannot be pardoned. So that is all completely related to crimes only. And now coming to the next last aspect, preemptive. What do you mean by preemptive? The word itself says preemptive. Means even before they are convicted, sometimes even before charges are clearly, mentioned also, pardoning power option is available in US. This concept is not there in India. As you rightly identified, like the Joe Biden issue, all those things. Even in the past, there are so many issues that even before they are convicted itself, US president has pardoned them. In India, we don't give it, which is actually good, because or else that would lead to kind of arbitrary misuse of power.
Yes, again a pretty straightforward question, and these are the questions we need to be ready, because again a 10 marker, if you are going to finish in 6.5 7 minutes, it gives you more time to analyze the other questions which are actually complicated, right? So let us move to the next question. Again, a question that is related to current affairs, especially with Jammu Kashmir elections that happened recently. Again, a very straightforward question. Discuss the nature of Jammu Kashmir Legislative Assembly after the Jammu Kashmir Reorganization Act 2019. Briefly discuss the powers and functions of the Assembly of the Union Territory of Jammu Kashmir. Yes, sir.
Yeah. So obviously, we all know that Article 370 was there till 2019. In other words, Article 370 was abrogated in 2019. Because of that, in addition to that, what they did, Parliament brought an act called as Jammu and Kashmir Reorganization Act 2019. So first, you need to mention basic details of this 2019 Act. Obviously, first point, what they did, it was passed under Article 3 of the Constitution. And 2, because of that, what happened, Jammu Kashmir was earlier a state, and which was later made a union territory and subdivided into J&K Union Territory and Ladakh Union Territory. J&K was given a separate legislature, which in the original act, the strength was 107. I think the further amendment has increased it to 114, which few of the seats are related to Pakistan occupied Kashmir. Those are all not important details for us. So that is a basic idea of the Jammu Kashmir Reorganization Act 2019. Then what you have to talk, that is mostly related to discuss the nature. Even if you want to tell nature of Jammu Kashmir Assembly, okay, a lot of students would have felt that I don't know, I have not read details about all these things. Even if they had used common sense and felt that it is another union territory, like how you have everybody will be knowing any serious candidate that only 3 union territories have their own legislature, which is obviously one is Puducherry, one is Delhi, another one is Jammu and Kashmir. So same things they could have mentioned. Nothing changes. That even though there is union territory for Jammu and Kashmir, yes, they can make laws on any subject in state list and concurrent list like any other state legislature. But like in case of Delhi, where in Delhi 3 subjects are exempted: police, public order, land. In J&K, police and public order is exempted. Means J&K Assembly will not have control on it. In other words, Government of India will have control on it. Other subjects, they can pass laws. But always, because it's a union territory, Parliament will have overriding power. They can make laws on any subject, anytime they want to, like with respect to any other union territories. That is broadly your, and of course, it has a Lieutenant Governor now. Any laws passed by Jammu Kashmir Assembly has to be approved by legislative Lieutenant Governor. In case of any differences between Lieutenant Governor and J&K Assembly, the issue will be forwarded to the President of India, who will take the final decision. It's like, if you remember your Delhi provision, more or less it is the same. Then obviously, to a little more detailed extent, you can go powers and functions of assembly. You can talk about, for example, legislative functions, as I just now told, executive function. You can subdivide judicial function. More or less, it is like the same with respect to any assembly.
It's more of application of presence of mind rather than trying to recollect whatever it is there. Just know that it is a union territory. Try to link it with Delhi and also any other powers and functions of normal assembly.
Yeah, exactly. Same thing. They can write about that 3 sessions will be there, and then collective responsibility angle is there. All of those things will remain the same. Nothing will change.
All right, sir. Thank you. Let's move to the next question. Again, a very predictable and straightforward question. I think it's a repeated question.
Very repeated question. Though their favorite topic is CAG and National Commissions, I am Finance Commission, but AG also, I think probably once or twice.
This comes under our constitutional bodies.
Correct. Constitutional body.
Again, if you observe, every subtopic in the syllabus will attract one question in the exam usually. So this question is about the Attorney General of India plays a crucial role in guiding the legal framework of the Union government and ensuring sound governance through legal counsel. Discuss his responsibilities, rights and limitations in the regard. Again, a very straightforward question asking the responsibility, rights and limitations.
Those are the 3 keywords: responsibility, rights and limitations. It is more or less purely, even if any serious students recalls the Attorney General topic, even if they had read Lakshmikant in those constitutional bodies also, just they have to replicate the same thing.
Article 76 provides for an
Start by writing about in introduction, Article 76 of the Constitution provides for Attorney General of India. He is considered the highest legal advisor to Government of India. Obviously, and then you just keep continuing. Like, for example, there is no clear eligibility criteria. Only major eligibility criteria is that he should be eligible to become a Supreme Court judge. Then obviously appointment will be, basics obviously you have to write. You can't directly jump to the responsibilities. You can tell appointed by the President. There is no selection committee, nothing. There is no fixed tenure. They function as long as the government, whichever has appointed them, is in power. As a convention, what they do, when the government has appointed them, goes away, they also resign. That's as a convention, not according to the constitution or any rule. Then automatically come to the make subdivisions, responsibility, rights limitation. Responsibility, the name itself is obviously, what is their responsibility? Provide legal advisors to Government of India whenever they demand.
Represent the union in Supreme Court and High Courts.
Government of India in either Supreme Court or any High Court. Represent Government of India for any issues related to Article 143. This what you call as
Presidential reference.
Jurisdiction, yeah, presidential references. Then they also have that extraordinary feature of attending the legislatures, attending the committees, defending the Government of India there. But of course, they cannot vote. They can only just go and attend. All those issues, obviously, you can write. And few additional ones are that they are not considered as an employee of Government of India. So they can continue their private practice. And but the limitations are, if they want to take up any criminal case, they have to take the permission of Government of India. If they want to take any position in any organization, they should take the permission of Government of India. No briefing against Government of India. All those you could have mentioned. Those are largely your limitations part.
To add some value, probably you can add the examples of the recent Attorney General KK Venugopal.
Venugopal,
and suggestion in Article 370.
Correct.
Value addition.
Yeah, those you can write. And more or less, it is the typical static part that they should recall.
But again, adding value through some presence of mind about who is the recent Attorney General and what are the recent acts that have been passed.
Last time what they had done was Attorney General of India, they had asked it as a 15 marker. That's a challenge because 15 marker you have to manage 3 sides. That will become challenging. I think 10 marker they would have easily handled it.
Yes. Let's start with the 6th question. Women's social capital complements in advancing empowerment and gender equity. Explain. Again, looks like a challenging question, but again, we should have some idea to decode it, sir.
Yeah, the question is related to social justice topic. Obviously, more or less, every year they have asked a question on women is the very, very favorite topic for UPSC. No doubt, we have always known that. This year, what they have done, normally they used to ask a question related to something like SSG or something like that. Now, this year, they have made us a little more broader topic called as social capital. That's it. How could you have approached it much better? The keyword is there called as social capital. First, start by telling in your introduction, what do you mean by social capital? In simple terms, tell it as social capital refers to ability of women or any particular group to trust each other, ability to work together, build a network.
Collective strength.
Exactly, collective strength. So, peer group, whatever keywords you use, that is called as your social capital. Best way, please define the term called as social capital. Now, next, obviously, they have clearly told you, link it to women empowerment, link it to gender equality. Gender equity, fine. Yeah, so obviously, you can make a subheading saying as a contribution of social capital to women empowerment and then mention examples like best example, first one is SSG. Like how women SSGs will lead to women coming together, how it will lead their, livelihood security or income generation or addressing their, so many other issues related to that. All of those things in 1 or 2 lines, 3 lines, you can sum up that. If you want examples, you can write Kudumbashri Yojana or Lijjat Papad issue or Seva in Ahmedabad, all those things. That is under women empowerment angle. Then obviously, when women's social capital is there, obviously that will help them in their greater representation in Panchayat Raj institutions, Gram Sabha meetings, Mahila Gram Sabha. There they can represent their women-specific, child-specific issue, address issues like it can be dowry issue, domestic violence issue, child marriage issue, whatever, those things also they can address. Then obviously that can lead to their better financial inclusion through microfinance networks. You can give examples like, for example, in Dharmasthala, there is a this microfinance institution example you can give, or the very famous, obviously, the Grameen Bank model, which is called as SSG microfinance model in India. That will all lead to your microfinance and this empowerment angle. Then if you still want to give, you can obviously link issues related to that women groups will contribute to raising their issues together, like this fighting for their rights, or that might lead to something like Chipko movement, Appiko movement, all those angles also you can bring. Then gender equity angle, obviously it's a little more broader, so that how it will lead to women empowerment, and then gender equity means men and women issues, how they can address it, will improve their decision making capability. So with it can address the issues related to patriarchy, all those angles, or maybe because of their issues only, this reservation panchayats have come up, reservation in now Lok Sabha and Rajya Sabha, this assembly has come up. Broadly, all of them, everything you can link anything related to, but the challenge is how will you bring the words of empowerment and gender equity? That's the issue. If they address that, automatically 10 marker will be done.
Okay, moving on to the next question. Next question is about governance. Again, if you observe, this is a predictable question.
Very
Yeah.
predictable question.
E-governance projects have built-in bias towards technology and back-end integration than user-centric designs. Example.
Correct.
Directly is asked you, what are the challenges of e-governance, especially in this technology bias as well as back-end integration?
Yeah, every year we have seen more or less from, I think, as far as I recall, 2017 or 2018, every single year they have asked a question on e-governance, and there's no drastic change in the demand also. More or less one or other keyword they keep adding. For example, one year they had asked a question on e-governance, Industrial Revolution 4.0. I think last year they had asked a question on interactive service model of e-governance. One year they asked about e-governance and the vital aspects, something like that. There's no drastic change. More or less the same demand. Introduction, start by writing about definition of e-governance, saying it refers to the effective use of ICT for efficient or effective delivery of goods and services to the citizens. Obviously, it will lead to better service delivery, all those things. If they want to mention, put a small mind map or mention about significance of e-governance if they want to. Then obviously, the question is built-in bias towards technology and back-end integration. In simple terms, what they are asking is that the e-governance projects, whatever we have now, right from NEGP of Manmohan Singh era to the Digital India projects, most of them are largely focusing on how to make use of technology and the integration, like ministry-wise integration, department-wise integration, Government of India state-wise integration. They are mostly focusing on that. Simple examples you can give. For example, if you look at Pragati, that's also kind of e-governance. They focus on integration of Government of India and state government. Then there is issues related to, that portal you can talk. Aadhaar-enabled payment system you can talk. So many things. Most of them focus on interdepartmental integration. Like for example, there is a portal related to MCA 21, related to corporate affairs. One ministry to another ministry, interdepartmental coordination is easy. So that means they are focusing more on technology, back-end integration. You can also link to digital public infrastructure, so many issues like the UPI related or BEAM related, all of that. Now that is also required, we are not saying no. But the question is saying it is biased towards them. In other words, they are neglecting citizens' demand, citizens' limitation, user-centric designs. Means user interface is not given that level of importance. And most of the users, beneficiaries will be from very illiterate background or less digital literate background. You need to give them content in very simple regional language. That is not given huge priority. Usage is still not very simple. It is more technology oriented. That aspects you need to focus
Awareness
more.
about data privacy.
Yeah, data privacy
That is also a
issues.
very big challenge.
Exactly,
Especially
data
we see
security
that lot
issues.
of our consumer data or the people's data is available for sale. So
Correct.
it shows the lack of data security in
Yes, cyber
models.
security
Yes.
challenges, all those things. So user centric is not there. You should just talk about digital literacy is rest. Beneficiaries still are mostly comfortable in the regional language, but content is largely prevalent in English and Hindi, or in other regional languages it is very less. And then user centric aspects are not there. Interface is still complicated. Those issues, if they are focused, automatically that itself you counter it and tell that along with that, how do you have to make it collaborate with technology companies, try to make it more easy. Regional languages content you need to increase, just make them, that's it.
Again, a pretty straightforward question. Let us come to the 8th question. Civil society organizations are often perceived as being anti-state actors than non-state actors. Right. Again, see here, he has asked, do you agree, justify?
Yeah.
Yes, sir.
Yeah, with respect to conclusion, just I'll clarify, because they're clearly asking you, do you agree, justify? So please never justify saying that it is anti-state, because in any democracy, civil society organizations are very, very important. They should be considered as partners in the development process. You cannot directly consider them as anti-state. So because they have clearly asked you, do you agree and justify? You can say that yes, why they are criticized as anti-state, you can talk, but don't agree that they are anti-state. Obviously, how do you have to structure it now? The topic is about civil society organization. So in the introduction, basic definition, you can write about CSO saying that it is a broader umbrella term which is called as a third actor. And how can you define them? It consists of all the non-state, non-market, non-profit actors who are considered or who are involved in the public interest. And so obviously it includes NGOs to SSG to cooperatives to trusts to philanthropic organization, pressure groups, all of them will fall under that. Obviously they have a very large role to play. If in case you want to write first about significance, you can write, or else you can first address about why are they considered as anti-state actors. You can talk about it. Obviously major reasons are what they tell, that they try to oppose any major development project that government tries to come ahead. For example, that was a major allegation against institutions like this Greenpeace International, all of them. And one of the IB report had told not long back means 7-8 years back, that because of their GDP is affected. And there is another allegation that they are you cannot say that few of them are also involved in compromising India's sovereignty and integrity. For example, the very famous anti-Kudankulam nuclear power plant protest was allegedly funded by mostly US, something like that kind of a one, and that they fund these activities related to Naxals or insurgents in central India or northeast India. Those are your major anti-state, that they are deliberately acting against state, protest, campaign, all these things. But obviously, they have a very large to play in the society. Write about those significance. Some famous examples of highlighting the problems faced by it can be Narmada Bachao Andolan kind of movement, or Me Too movement, or anything that, what do you call this, Nirbhaya related issues, or like how MKSS has contributed to Jan Sunwai initiative, RTI, that all positives you can write.
So basically, they have complemented the government and also held government accountable.
Yes. As you famously keep telling, that they are voice of the voiceless, they are face of the faceless. You cannot consider them directly as anti-state. If in case, yes, there are some misuses, there are acts. FCRA Act is there, Foreign Contribution Regulation Act. And obviously, Government of India had also told, even CBI and one of the reports had told, that they should mandatorily submit their audit and account reports, because only less than 10% of them submit that.
Coming to the next question, coming to IR questions. So the first question, the ninth question.
I'll read the question, you can address it better, Shashank Sir, because India-Africa digital partnership is achieving mutual respect, co-development, and long-term institutional partnerships. Elaborate. Yeah, please continue, sir.
So again, here we have to see the demand of the question. Again, it comes under, say, you can say India and extended neighborhood.
Correct.
So where we are talking about India and Africa digital partnership. Today, if you observe, technology has become the driver of 21st century international relations. Earlier, it was economics, but now it is technology.
Sure.
So they have integrated technology as well as India in playing a vital role in South-South cooperation, where 54 African nations are a part of Global South. So here we can start the answer saying that India and Africa share common civilizational, historical roots. And then the main demand of the question is how digital partnership is achieving mutual respect.
Those three keywords, yes. Mutual respect, co-development,
and long-term institutional partnership. So again, mutual respect, again, both of us have a lot of things in common, promoting South-South cooperation, etc. But again, here we have to observe digital partnership.
Digital partnership, that's the keyword.
Africa has a lot of needs. They have low digital penetration, lot of unbanked population, gaps in e-governance. This is where India has its strength. For example, India has contributed in tele-education and telemedicine in the name of e-Arogya Bharati and e-Vidya Bharati. There's another scheme called as Pan-Africa e-Network.
Pan-Africa e-Network,
landmark project in Africa. Also, recently, digital payment systems, the UPI platform of India has also been implemented in a lot of African nations like Namibia. Correct. So, in this way, technology has played a very important role in co-development. Other technology is also being provided. And we have to link it with long-term institutional partnership. Institutional partnership we can talk about is the Indo-Africa Growth Summit or the Forum Summit that is happening every 3 years, that is going to be scheduled this year. So, this is how we are going to link this to institutional partnership. So, this is about the 10th question. Again, a little bit of current affairs and a little bit of basics. But again, if you observe, Africa is a favorite area of UPSC. All right.
So as you identified, the key word is digital partnership. How do you use that and link to mutual respect, co-development, and institutional partnerships? That's it. And I think it's a very regularly they keep asking questions on Africa also. I think they would have easily done. Yeah, next question, which is as obviously we have told multiple times, continuously it is in news for at least you can say from almost the post-COVID era. With the waning of globalization, post-Cold War world is becoming a site of sovereign nationalism. Yeah, two keywords, globalization and sovereign nationalism. How can you structure this particular question, sir?
So here again, if you read the question again, with the waning of globalization, post-Cold War world is becoming a site of sovereign nationalism. Elucidate. So basically the demand here is, why do we see that globalization is waning or reducing, and also how is it being manifested? Okay. So again, the post-Cold War world order was actually an era of globalization till let's say early 2000s. For example, we can see the rise of multilateral institution, free trade, liberalism, free movement of people, culture, barriers, goods, services across the border. But why did globalization start waning? Here we have to see multiple reasons. One is the economic cause, especially after 2008 financial crisis and how it impacted the world. So that became a very important reason for the decline of globalization. Along with this, geopolitical causes like the Russia-Ukraine war and the COVID also, which led to a lot of supply chain crisis, which actually exposed the flaws that are there in globalization or the current model of globalization. Along with this, the domestic populism in the form of rise of right-wing governments. For example, US government, Make America Great Again was a slogan of US. A lot of right-wing governments have started closing their borders, especially in Europe. So this also led to the waning of globalization. And the features, now see the second part of the question is sovereign nationalism. For example, yes, economic nationalism, we see that in India we are focusing on Atmanirbhar Bharat. Or for example, technological sovereignty, US CHIPS Act, or for example, focus on domestic semiconductor manufacturing. And also cultural nationalism that is also happening in the form of closing down the borders, etc. And that can also be substantiated with the example of rise of xenophobic attacks on outsiders. Right, so this is about
maybe they can also link to that multilateral institutions are reducing now. That week you guys keep talking about
the losing relevance of WTO, the losing relevance of UNESCO, United Nations. All this is an indication of the waning of globalization and the global world becoming a stage of sovereign nationalism. And again, so what should be the future here? Again, the future is going to be selective globalization. But again, nonetheless, is in India's context, if we speak, we can focusing more on becoming a self-reliant economy, at the same time exploring global markets abroad. So this can be India's way ahead.
Broadly in and around, if they obviously structure it, it's very easy for a 10 marker.
Yes.
Yeah, okay. And now let's go to the 15 markers.
Yes. So the 11th question, again, it's about constitutional morality. So constitutional morality is the fulcrum which acts as an essential check upon high functionaries and citizens alike. In view of the above observation of the Supreme Court, explain the concept of constitutional morality and its application to ensure balance between judicial independence and judicial accountability in India. So I think, sir, there's an interplay of lot of current affairs that is there, especially with accountability of the Yashwant Verma case and also the constitutional morality doctrine that has been brought in the last few years.
Yeah, so obviously the topic is one of the kind of favorite for UPSC also, both in prelims as well as mains. Constitutional morality question, basic structure, constitutional morality. More or less they keep asking questions on that alternatively. So how do you have to structure it? Clearly they have told you, first they have given a broader statement. Clear sub-questions are, explain the concept of constitutional morality. That's your sub-part 1. Then its application, in general application first, especially to ensure balance between judicial independence and accountability. How do you have to structure it? First, you have to define the term constitutional morality. As there is a very famous statement of Ambedkar, directly you can write that Dr. Ambedkar had defined that constitutional morality is about adherence to the core principles of the constitution by both people in power as well as citizens. That's a basic definition of constitutional morality. Obviously, there is no exact what features like how all these are constitutional morality, but broadly, as Supreme Court told in multiple cases, that it broadly includes most of the values or the ideals in the preamble, like equality, liberty, fraternity, justice, unity, integrity. In addition, you can add secularism, the rule of law. All these separation of power will broadly fall under constitutional morality. Now, Supreme Court had referred to it in various cases. You can just mention about it. For example, they had mentioned about it in Sabrimala case, Navtej Singh Johar case, and Lieutenant Governor Delhi versus Chief Minister, that is NCT Delhi versus Union of India case also, they had mentioned about it. Very famous statement, if you have heard, that constitutional morality will prevail over social morality, customary morality. Those are all very famous statements. This will become your basic one. You can also talk about, because they have told about, explain, if in case you know, write broadly about the significance of constitutional morality. More or less, it is like your significance of basic structure, that it will ensure that the constitutionalism is prevalent, nobody misuses their power, concentration of power or arbitrary misuse of power will not be there. Those are our, the judiciary will ensure that there is a checks and balances. All those you can write it as a basic importance. Now, especially the next part is a little challenging, that how do you link it to ensuring balance between accountability and independence of judiciary. Obviously, we all know that judicial independence itself is part of basic structure. But the major issue is what? The judiciary is misusing its independence is also an allegation. For that, you can tell that there are allegations, like for example, that if you take Collegium system, the major allegation is that it is a victim of nepotism, favoritism that is there. The meetings are not transparent, it is not subjected largely to RTI, memorandum of meetings are not there. And then obviously with respect to the questioning part, that largely even though removal option is there under 124, they are not removed. As Shashank Sir told, the recent issue with respect to Justice Yashwant Verma, that is also there. Then yes, they have the power of judicial review, which sometimes they make it as judicial activism, but they also lead to judicial overreach. That is a kind of misuse. So that in and around that you have to frame and say that even though Supreme Court should have its independence, they should self-regulate themselves and they should not lead it to judicial overreach, and they should maintain a balance between both. Same way, obviously Parliament can come up with few measures to ensure that balance, like maybe we can bring back NJAC as Law Commission, as second ARC, everybody have told. And obviously the judges should have their own code of conduct based on, they have a broader conduct called as Bangalore National Law School Principles, restatement of the judicial values and judicial conduct, that they can use it so that they can ensure a balance. The core, that is a point. The point is that you cannot make everything as detailed rules. Judges should only make sure that their independence and their accountability is balanced, because checks and balances, separation of power, limited power is the core basis of is the core of your basic structure. In and around that, they have to make sure, or if in case they want to, they can also give examples that in the previous there was an allegation against Justice Deepak Mishra, Justice Ranjan Gogoi issue was there, wherein he looked into a case related, there was a case and he only looked into it, principle of natural justice violated. That is also a violation of constitutional morality.
So basically we can say that as sunlight is the best disinfectant,
Correct.
Transparency is very important to gain the trust of judiciary and ensure that constitutional morality is actually upheld in true spirit.
What they have to link is the judicial independence, accountability, and some 2 to 3 examples they could have brought in.
The next question, a pretty straightforward question from the syllabus. Indian Constitution has conferred the amending power on the ordinary legislative institutions with a few procedural hurdles. In view of this statement, examine the procedural and the substantive limitations on the amending power of the Parliament to change the Constitution. So here again, a pretty straightforward question, sir. He is asking you what is the amending power in an ordinary manner, and again, what are the limitations?
Sure.
Yes, sir, please.
Very straightforward question. Obviously, the question is related to Article 368. In the introduction, please mention about Article 368, Part 20 of the Constitution, because it's a polity question, evaluator will be expecting it. And even if you recall, you can write about that Article 368 clearly says that Parliament can amend any provision of the Constitution either by addition or variation or repeal according to the procedure mentioned. That you should first mention that. Then they have used a little keyword that Constitution has conferred this power on the ordinary legislative institutions with few procedural hurdles. Why? What is that ordinary legislative institution? Is that in India, Parliament itself can amend the Constitution, though Constituent Assembly separately drafted the Constitution. But in other words, the angle to that is that in so many other countries, to amend the Constitution, they create a separate body itself for that. In India, there is no separate body. Parliament itself will take care of it. For example, even in US, they have a concept called as Constitutional Convention. Even in Australia, Canada, they have a separate body to amend Constitution. In India, Parliament only take care of that. That is the core point. Then obviously, with few procedural hurdles, within that they have to examine the procedural limitation, substantive limitation. Obviously, you can write few basics. Remember, it's a 15 marker. Don't directly, if you go to the demand of the question, then because it's a static one, there is no major analytical part, there is no major current affairs angles. So don't directly jump. Talk about obviously that the Constitution amendment is based on the concept of doctrine of living tree, that it's a balance between rigidity and flexibility, and then get to the overall, that Article 368 procedure also you can say that who can introduce the bill. All those basics you will be knowing, that it can be introduced either by a private member or a minister. There is no need of president's permission, and obviously both have to pass it separately by special majority. There is no need of joint sitting, or there is joint sitting is not allowed. President's assent is mandatory, and it is the president has no veto also. 24th Amendment 1971 first mentioned that. Then they are clearly telling you procedural limitation, substantive limitation. Procedural limitation is first what we told now, that you have to clearly follow a procedure aspect. President's permission, president has to mandatorily give the assent. Those are all procedural limitation. And to amend few provisions, you have to follow special majority. to amend few other provisions along with special majority. Ratification of 50% of states is required. Mostly, you know that very basics, federalism related, largely present. That you can write. Very basic static question. Substantive means what? That even though you can follow the procedure, few provisions you cannot touch. Simple, obviously, everybody knows that if in case any law tries to what you call this compromise fundamental rights, Article 13 will be violated, it will be declared as unconstitutional. Another very basic, that is the basic structure aspect, those core provisions of the constitution which cannot be amended whatsoever, Keshwananda Bharati case. So that is another substantive one. Then if in case you try, judicial review is there, obviously that's a major one. Obviously that if in case you try to go and violate any provisional of the constitution, it will be declared as ultra vires unconstitutional. Supreme Court has done it. If you want recent example, 99th constitutional amendment, NJSC related, Supreme Court quashed it, saying independence of judiciary is violated. Like that, you need to come up with that. If in case they have additional provision, they can compare with some other constitutions like US, Canada. Like in Canada, it's too rigid, you can't even amend. In US also, it is very rigid. All those provisions they can compare and write if they want to. That's the depending on how much have they managed the space.
Thank you, sir. So the next question, coming to the 13th question, again a very predictable question. Yes, judiciary you have around 4 to 5 topics. Not anything. They can't ask anything outside this. So discuss the evolution of collegium system. Critically examine the advantages and disadvantages of the system of appointment of judges of the Supreme Court of India and that of USA. Directly, straightforward question.
And any serious candidate can easily write that. Only a little challenge is that because at the end they have mentioned about Supreme Court of India and that of US. The US judicial appointment, if they have an idea, it is more easy to handle. Obviously, if in the case, I'll just tell you the broader structure so that you will get an idea. Obviously, first rather than directly mentioning about Collegium, tell about Article 124. According to Article 124 of the Constitution, how are judges of Indian Supreme Court appointed? Talk about that. Obviously, we all know, appointed by the President in consultation with the Chief Justice of India and such other judges of Supreme Court and High Court as President deems necessary. That's very basic. Then you can tell about, obviously, evolution of collegium system.
So
first judge,
the problem was, is consultation
judges.
is equal to concurrence?
Yes,
that was the biggest
exactly.
debate. So in first judges cases, again they said that consultation is not equal to concurrence. Yes. However, in the second judge's case, we started having a collegium where the Chief Justice of India with 2 senior most judges. Correct. That was the evolution of the second judge's case. And the third judge's case, we added 2 more Supreme Court judges. So it became 1 plus 4. So this was the evolution of collegium system. Also, you can talk about the 99th amendment, which spoke about NJAC. That is also sometimes referred as a 4 judges cases, where again a collegium was being replaced by.
Yes. And obviously, they are talking about advantages and disadvantages of the system of appointment of judges. In India, obviously, collegium system you have. Actually, they have an advantage also. You cannot deny that. The advantage is obviously, first major reason is what? That it will ensure independence of judiciary. So, executive and legislature cannot interfere in that. Why is that necessary? Because independence of judiciary itself is basic structure. In more than 40% of the cases in Supreme Court, Government of India itself is a party to it. Obviously, if Government of India appoints them, conflict of interest, very easy kind of bias will be there. Checks and balances, separation of power, constitutionalism cannot be managed if the judicial appointment is done by legislature and executive. And judiciary is one of the most trusted institution. If that has to be retained, it has to be.
There's also a statement which you can write. It is good if there is justice in politics, but it is dangerous if you bring in politics in justice.
Yeah, very good. That statements will add a lot of value.
So that will add a lot of value here.
And then at disadvantages, which is also very obvious, that collegium is not mentioned in constitution. It has no constitutional basis.
Imperium in imperio.
Yeah, imperium in imperio. Exactly. It will create a kind of empire within an empire. Appointments are, the meetings are very opaque. Criteria are not very clear.
Nowhere in the world where judges.
Yeah, nowhere in the world. No major democracy. UK, US, Canada, Australia, Germany. Nowhere judges will appoint themselves. Natural justice is violated.
Yes.
And few people criticize it as uncle judges syndrome also, or to put it a little more moderately, favoritism, nepotism issues are there. All these are criticism. To address that, they came up with all those, 99th Amendment NJSC, which was also quashed. Then now the issue is you have to link it to judges appointment in US. Yes. In US, obviously appointed directly by the President. So executive is involved. But what they tell is that US Senate has to approve it.
Confirm.
Yeah, the US Senate has to approve it. Within that, there is one of the procedure is that US Senate will conduct US Senate has a committee. That committee will conduct hearings in which people can give their feedback. Based on that, US Senate will approve.
The
Yeah,
vetting
it's-
procedure is very stringent there.
Yes, it's an advantage also in a way. The advantage is that it's more transparent, it's more accountable, legislature is involved, executive is involved, people feedback are also taken. Those are all advantages. Criticism is that judicial independence might be compromised, and the very famous criticism of US judiciary is that depending on the which party is in power, their own ideological people
Politicization of judiciary will.
politicization is very, very high.
Okay.
Yeah. So hence, as a conclusion, what they can tell is that we should ensure judicial independence, but appointment cannot be what compromising the accountability. So as Law Commission and second ARC told, we need something like Judicial Appointments Commission. That is absolutely no doubt about it.
Okay, sir. A small message to the students who are preparing for the next year. See, these are all very predictable questions. If you are ready with this, it is going to give a lot of value and is going to save a lot of time and give you a lot of marks also.
Right.
Because again, other aspects apart from collegium in judiciary, if you can predict is judicial overreach, judicial activism and judicial review.
Yeah.
UPSC has to ask you one of these questions.
Maybe in
addition, Yes.
judicial pendency.
Judicial pendency of cases and All India Judicial Service.
All
Apart
India
from this, he
Judicial
cannot ask you anything.
Yes.
So if you are prepared, this is where you are going to score good marks. All right. Let us go to the next question. Again, a predictable question in the light of fiscal federalism. A very big debate has been happening in the last few years. Especially the government of Karnataka and the government of opposition ruled parties have raised this. Examine the evolving pattern of center-state financial relations in the context of planned development in India. So basically, he's asking you how it was during the planning commission time and how it has evolved in the 21st century. Yes. Yes. And also, how far have the recent reforms impacted the fiscal federalism in India? Recent reforms, you should have an idea about GST and another couple of reforms.
Correct.
So, yes, sir.
Yeah, so obviously, as you correctly identified, the key word is here evolving pattern. If you just write about center-state financial relations and don't address the evolving pattern and planned development, that means your answer will be, what do you call this? You will not be addressing the overall demand. So hence, obviously, we all know that India follows, structure-wise, how do you have to tell that India follows very strong quasi-federal model, more largely based on the Canadian one. Hence, post-independence, most of our larger part of our financial control is with the center. And obviously, we know because they're linked into planned development, India followed a centralized planned development model, largely driven by 5-year plans and planning commission. Obviously, center had the larger financial control on income tax, it can be on corporate tax, it can be on customs duty, it can be, and they largely identified the plans, and through their centrally sponsored scheme, all those things, they devolved the funds to the states. If they have a better idea, they can tell that for a long time, till almost 1980s, or if you look at the first finance commission headed by K.C. Niyogi, vertical devolution to the states was in single digits, 8%, 7%. Only gradually post 1991, it increased. So that pattern you have to write, that how planning commission 5-year plan dominated center-state financial relation before 1991. Fine, because at that time we followed centralized model. Yes, finance commission was there, but it was not very, very powerful one. Fine, then you have to talk about post 1991. Obviously, post 1991, we gradually shifted towards cooperative federalism and competitive federalism. Gradually, vertical devolution has kept on increasing, and centrally sponsored schemes also rationalization has happened. That point you have to.
So we can here also talk about how with the removal of planning commission and replacement of Niti Aayog
recent reforms angle,
and how finance commission became a very powerful body for vertical devolution as well as horizontal devolution.
In the recent reforms, as you identified now, you have to tell some 4 or 5 major reforms are there. First major issue is planning commission, which dominated entire center-state financial relation, replaced now by Niti Aayog, which has no financial power at all. 2, another major issue is GST and 101st Constitutional Amendment and GST Act 2019, very, very major issue you have to tell. Then, especially from 14th Finance Commission, 42% vertical devolution, 15th, 41. Those 3 are very, very major. If they want to add, they can tell about the rationalization of centrally sponsored scheme, in which tied grants have reduced, untied grants and flexi funds have increased. Now, states can performance grants have increased based on their own needs. They can come up with the plans.
Also, we can talk about the FRBM Act also.
Yeah, correct. FRBM Act also you can talk about it. Obviously, it has improved a lot. Then, of course, you can identify a few challenges, saying that even today there are allegations that government of Karnataka had made an allegation of My Tax, My Right campaign, that there is North-South issue which is continuously going on even today. Tamil Nadu also recently alleged that actually it is not 41%, it is less than that, 37, 38% they are alleging. GST compensation issues are there. And now planning commission, because they don't handle, or Niti Aayog doesn't handle it, directly Ministry of Finance handle it. That also is a kind of controversial aspect. All those angles.
Also, we can write that sometimes political compulsions also force devolution of funds, like how funds were
Yes,
given.
yes, yes.
That also
Yeah,
can be
for example, there is an allegation of double engine sarkar might negatively affect parties with different states with different parties in power.
Again, so here recent reforms can be positive, can be negative.
Yes,
both should be addressed here. Right? Yes, sir. So let us go to the next question. Again, about pressure groups. What are environmental pressure groups? Discuss their role in raising awareness and influencing policies and advocating for environmental protection in India. Directly has given us the subheadings also what is to be written. And again, if you observe, environment is another favorite area of UPSC. Yes. I remember in 2022, a question was asked on role of judiciary in environmental protection. Correct. Now he has just replaced judiciary by pressure groups. All right. So again, kind of pretty straightforward question. Again, here you should be knowing our names of a few pressure groups which are working in the field of environment. Yes. How they have played a very important role in bringing in policy advocation. You can also talk about how NGT was an influence by a pressure group. Yes. So right now, because earlier environment was not at all a part of public policy debate, and only thanks to pressure groups do we see environment as a part of our policy reforms. Yeah, correct. Yes, yeah, obviously, as you rightly identified, in the introduction part, what if they want to, first broadly they can talk about definition of a pressure group. If they want to, they can tell that pressure groups is part of civil society. It refers to group of individuals who come together voluntarily and try to put pressure on the government to fulfill their demands or get policies or programs in their favor. Of course, they are linking it to environmental pressure group. That means they are specifically focusing on environment related issues. Very, very famous examples are there. You can write about right from which one Chipko movement to Narmada Bachao Andolan to Apiko movement. Silent Valley. Yeah, Silent Valley movement. All those, so many examples are there. Or in the, what do you call, in Mumbai or in Bangalore, anti-steel fire protest was there. All of them largely is related to protest of Mumbai. Yes. Yeah, that is there. And then Hasdi Aranya protest recently, Niyamgiri protest. All of them are environment related pressure groups. Of course, now the keyword is you have to link it to for raising awareness, influence policy, advocating. Yeah, obviously in general, we would have identified that pressure groups normally use three major techniques. One is electioneering, lobbying, propaganda. If you want to, you can talk about it because it's a 15 marker, or else if you have more content, directly write about raising awareness. Obviously, a lot of pressure groups are involved in raising awareness about soil conservation, water conservation, afforestation. For example, in Rajasthan, he is famously called as what Rajendra Singh is famously called as Waterman of India. He is involved in raising awareness about conservation of local water bodies. Or if you talk about what you call this Vandana Shiva's group called as Navadanya, she is involved in raising awareness about conservation, or you can talk about revival of our native seeds. Yeah, native seeds, because she is against this GM crops, hybrid crops, green revolution, all those things. That is about awareness issue. Then obviously influencing policies, again very famous ones are there. Narmada Bachao Andolan itself led to Supreme Court's rehabilitation compensation policy. That itself actually led to the landmark LAR Act, what we call it as Land Acquisition, Rehabilitation, Resettlement Act. Same way, a lot of NGOs impact led to, as you told, NGT Act also it led to that. Or even Forest Rights Act also was largely because of the influence of this environmental pressure groups. Then advocating for environmental protection. So many times, for example, in Bangalore a few years back, they proposed a steel flyover, and because of the protest, they took it back. Steel flyover Beda campaign. Yeah, steel flyover Beda campaign. Yes. And then this Niyamgiri issue in Odisha, because of this Vedanta group and Dongria Cone tribes were affected. It's a kind of tribal angle also, environmental angle also. So, and then Supreme Court intervened and they told, conduct a, as the people itself there. Yeah, and then the entire project was stopped. Now recently Hasdi Aranya protests are going on continuously, that is in news. So these are all, so many examples are there. In Western Ghats also there is a very famous NGO called as A-Tree who is also acting for afforestation issues and the Western Ghats protection issue. There's so many, as you told, Silent Valley movement was there in the past, that was also taken back. You can keep on writing about them. It's a very huge topic. So, a message here is, please, whenever you are reading the newspaper or whenever you are following these topics, please try to link it with which question or where can I use it in my mains answers. Yeah. That is when you can easily relate and write answers. Yes, current affairs matters a lot for it. And then obviously they can write another dimension saying that sometimes what will happen, they'll try to put too much of pressure so that the balance between environment and economy will get affected. Too much of, if you focus on too much of rapid growth, yes, environment will get affected. We have seen in Wayanad issue, we have seen in Uttarakhand issue, Joshimath issue, agreed. But if they
keep on protesting against each and every project, then GDP will get affected, which intelligence.
The Greenpeace example is also one you can write. Greenpeace as well as the Kudankulam power plant, which is actually harming the environment. So again, the balance between development and environment should be taken care.
Yeah, so for that they can tell that environmental impact assessment and Environment Protection Act is there, Forest Conservation Act is there. So we need a balance. The key is balance. And for that, obviously, so many recommendations are there. Madgil-Gadgil committee report on Western Ghats protection, all of that you can keep writing about them.
So let us move to the next question, the 16th question. Inequality in the ownership pattern of resources is one of the major causes of poverty. So again, the question is about poverty and how inequality in ownership pattern of resources as a major cause. Discuss in the context of paradox of poverty.
Evaluator will be expecting you to address two key terms. Ownership pattern of resources, paradox of poverty. If you don't convince the evaluator that you understand these two keywords, then he will not be convinced that you know the demand of the question. Obviously, poverty is a very broader topic. In social justice, you would have discussed in detail. Even though you might not have written specifically about ownership pattern, logically you can, at that moment itself, you can decode inequality in ownership pattern. In other words, they are telling that ownership pattern of resources is what it can be related to land, it can be related to industries, it can be related to some other resources, credit access, capital, all those ones. That there is a huge inequality is what our wealth itself in general, there is huge inequality. For that, obviously, you identify that poverty is a broader issue. There are so many causes for it, right from whatever, so many issues. We can sum up very quickly in a kind of 2 or 3 line paragraph, but then directly come to the ownership pattern, inequality in ownership pattern. For example, as Oxfam report had told, the top 1% own minimum 45%, or if you write other way, top 10% of Indians own almost 70%, or as Shashank Sir had
last 50%, the bottom 50% have only 3% of ownership.
Yes, exactly. So that is a kind of inequality with respect to the wealth ownership. Land also, obviously, we all know that at the time of independence, actually top 5% zamindars were owning more than 80%. Even today, there is huge concentration of land ownership. You can substantiate with facts saying that according to even agricultural census, even according to economic survey also, small and marginal farmers are more than 80% in India. That again shows land is also concentrated. Even if you look at the big industries, most of it is under a few big industrials or capitalist, families also.
Again, here you can split the answer into agriculture, manufacturing and services sector also, which will give you some more fodder to write.
That is much better.
Right. So that is in that way I can, because you have to write 3 pages in this answer. Yes. Also, one thing you can do is, again, if you are lacking content, talk about measures taken by the government or what can be done to address this problem of paradox of poverty.
Yeah. So the point is, once they identify the ownership pattern of resources inequality, link it to poverty. For example, because too many small and marginal farmers are there, they don't have access to too much of land. Automatically, property ownership is lacking. They lack access to the credit. Livelihood also will be less.
Encourage the formation of cooperatives so that
those are way forward you can have it. But next keyword is you have to address the paradox of poverty. What do you mean by paradox of poverty? You have to explain in the beginning wherever possible. Paradox means it was simple terms that referring to that even though there is a lot of wealth in India, there is a lot of resources in India, it is concentrated. It is in only few hands. India recently has become a $4 trillion economy, but still one of the largest multidimensional poverty is in India. India ranks very high, in other words, very low in global hunger index. All those issues they can talk about it. That even today, India is very food surplus nation, but malnutrition is still very high. That is the paradox of poverty concept you have to explain. Then, as it obviously Shashank told, lot of measures government, it's a social justice. Of course, you have to write what measures we have taken. Within measures, you can subdivide legal measures, policy related measure, welfare program related measure,
financial inclusion.
Financial inclusion, technology related measure. Then, if you want, of course, not if you want, it's better you write some solutions saying that how you can address it. Maybe, as they famously keep criticizing, that in India land reform is an incomplete project. That can we bring about cooperative farming, or maybe let's say can we address by talking about community ownership? Is it possible? Something like that. You have to address all of them. Obviously, credit access, financial inclusion. How can you increase through progressive taxation, or by through other measures? How can you make sure that you will have ownership or entrepreneurship from other sections of society? All of those measures you need to mention in your way forward.
All right. So next, coming to the 17th question. In contemporary development models, the decision making and problem solving responsibilities are not located close to the source of information and execution, defeating the objectives of development critically evaluate. This looks suddenly like a very difficult question and very out of the box. But again, if you decode this, basically they are talking about the Panchayat Raj and the urban local bodies and how actually governance is not happening in the grassroots level, but how we are still continuing a top-down approach.
Yeah, largely it is about centralization or some decentralization issue. They're clearly telling you that for a long time, India's they have not told India, but contemporary development models, centralization has dominated. That is the point called as decision making and problem solving, not located close to source of information, means grassroots level. So government of India is taking decisions. So at the local level, Gram Sabhas or ward committees or whatever panchayat municipalities are not involved so much is the core question. So you have to talk about it, obviously saying that, like, even if you trace it to India, that like what in one of the questions we discussed about, that post-independence we follow centralized top-down development model in which decisions were taken at the central level through 5-year plans and planning commissions. For that, what is the loopholes of that? That you should first establish that centralization model has its loopholes. Then you have to come to the advantages of decentralization. You can easily tell saying that one size fits all development model, that in a complex, diverse country, how are you assuming that the needs of entire country is the same? Obviously, local level people, you are not involving in decision making. They will not have a sense of ownership. All those, and there will be subordinate level officers will not be involved in any kind of decision making. You will not be addressing the local problems there. So all those issues you have to tell. For example, the needs of Kerala will be different, needs of UP will be different, need of Gujarat will be different, need of Mizoram will be different. Within a state, there are intra-state, intra-district differences. All these will be neglected in centralization model. India also recognized it. That's why we came up with 73rd Amendment, 74th Amendment, Gram Sabha, all of those things. Post-independence or post-1991, now we are encouraging more of decentralization. That also you can give example, like Gram Sabha, people's, Gram Panchayat Development Plan, People's Plan campaign in Kerala, all those you have to keep. Yeah, social audits at the local level. That you need to come up with that source of, closer to source of information and execution. Give some basic, famous example, if you know, famous models of Anna Hazare's Ralegaon Siddhi model, we keep telling, Popatra Bauji's, one of the villages there, that all we keep talking about decentralized model of development. But you can also generate a dimension and say, but in some issues, centralization is also equally important. For example, something like to ensure vaccine delivery across the country, or Aadhaar implementation, or NEP for that matter, defense for that matter, centralization is also required. Each and everything you can't decentralize. So we need a balance between both. And you can use keywords like principle of subsidiarity, all of those angles you can keep on adding to the core challenge will be, if you understand that the issue is about centralization or decentralization, points will automatically flow.
So let us move to the 18th question, sorry. It's about the National Commission for Protection of Child Rights has to address the challenges faced by children in the digital era. Examine the existing policies and suggest measures that the Commission can initiate to tackle this issue. So broadly, if you observe, 3 direct questions have been asked. Has to address the challenges faced by the children in the digital era. Second one is existing policies regarding children and the existing policies for the threats for children. And third one is what measures can be taken. Yes, sir.
Yeah, so obviously in the beginning you have to question is about, it's a kind of, they have mixed so many things here. It's a question about statutory body. It's a kind of polity question, but they have brought the children angle, that means social justice angle, and then they have also brought the policy angle. So it's a kind of combination of polity, governance as well as social justice. Okay, obviously the question is about NCPCR. First tell about it, that it's a statutory body established under National Commission for Protection of Child Rights Act. Obviously, you will also have State Commission for Protection of Child Rights Act, like how you have NHRC, HHRC, same way. Because it's a 15 marker, write briefly about what is its in general function. As the body itself says clearly, obviously it is to protect the rights of the children. So they will examine the constitutional, legal safeguards available for children, give recommendations for Government of India and the state governments, especially Government of India. State Commission will take care of the state angle to bring any reforms, and obviously it will have all the powers of a civil code. So they can they can summon anybody, ask for any documents. But as any other commission, their recommendations are not binding. It's not a constitutional body, and obviously appointments will be largely controlled by Government of India. Those are all kind of loopholes.
And you can add it is in charge of monitoring of 3 important
issues. So that is your Exactly.
Juvenile Justice Act and
Mm.
also our
Correct. Yeah.
POXO Act.
That is briefly in the beginning, as I told, briefly write about NCPCR, because that is not, they are not asking about NCPCR in general. I just told you because it's a 15 marker. Now, specially talk about what are the challenges faced by children in the digital era. Generally, everybody will be knowing the issues related to their online bullying, or it can be related to the child pornography or online gaming addiction, sexual abuse, or it can be what you call this, their privacy related compromises sometimes. Because they are talking about children, that means largely less than 18, parental control is not so easy. So age verification is not so easy there. And then they might get sexually exploited also. Or there are a lot of issues like digital, what do you call
Deepfakes.
deepfakes are there. So digital arrest can also happen. We don't know. All those are challenges faced by.
Example of the Blue Whale game also.
Yeah, Blue Whale gaming issue was there. Those are all challenges faced by children in the digital era. Now, examine the existing policies which are there. For example, obviously, there is an act related. Obviously, we all know Digital Data Protection Act is there. POXO is there, in which any kind of child sexual harassment will be considered as a crime, including online related things also. There is a framework. Juvenile Justice Care Act is also there. These are all existing policies, existing laws.
You can also talk about the recent IT rules of 20.
IT rules is there, exactly, correct.
Yeah, because it takes immediate action against, I think within 24 hours.
Correct,
the internet
exactly.
have to take action against any such violent content or sexual
content. And then the rules clearly say that the control should be with the parents.
Yes.
And age verification should be very, very strict.
The main problem here is age verification, or what we call age assurance predictability. Because they just ask, are you over 18, press enter to enter. I mean, that's how they check. But we need more stringent models of age assurance or age verification.
Yeah, and obviously because they're asking you examine, once you mention these IT rules, POXO, juvenile justice care or digital data protection also, national child policy is also there. What you have to also identify is that it is not so easy to in ensuring that they don't get exploited in the digital aspect, because learning is also required, especially post-COVID. Online learnings have increased a lot. A lot of classes happen online. Digital missions are there. One, they may get addicted, and two, obviously, they might get exploited also. Age verification, all these issues are there. Then the last aspect, what measures will you take to tackle the issue? Obviously, there's a few measures are there. For example, one of the major measures is that under Digital Data Protection Act, you can come up with a child-specific related framework. They can come up with it. Then under IT rules, you can make it more strict and make this digital intermediaries more accountable for that. Then especially for both children also, especially for their parents, we need digital awareness campaigns, so that how can they regulate children's behavior, how can you balance their learning and their safety. And then you have to make it very, very stringent. Punishment should be there in case of any kind of child pornography issues or child bullying or child sexual harassment. Punishment has to be very, very strict, because as UNESCO had identified that if they face this kind of issues in their very young age, obviously it will have a lot of impact on their psychological impact, trauma, cognitive development issues will be very, very serious on their future.
Talk about legal level, institutional level, at societal level, what can be done?
School
level, inculcating all this in the curriculum, awareness generation amongst the kids as well as their parents. All this will go on play a very important role, so that we provide a very safe online space for children, so that the online digital space is used for their well-being as well as their education.
Correct.
So
correct.
We can conclude this also.
Yeah.
Yes.
Yeah. Next, I'll ask you. I will discuss it. Energy security constitutes. The question is about first keyword. Energy security constitutes the dominant kingpin, means key feature of India's foreign policy. That's the context, and is linked with India's overarching influence in Middle Eastern countries. So, energy security and Middle East is a link here, and foreign policy. Then the real demand of the question: how would you integrate energy security with India's foreign policy trajectory in the coming years? Looks like a little more analytical question.
A tricky question to generate a lot of points, but again, how are we going to still write a complete answer? So here, directly, let us not start with energy security, or you can say, what is the main objective of India's foreign policy? And it is to fulfill our national interest.
Correct.
And one such national interest is energy security. What is energy security? Affordable, accessible, and available energy. That is the definition of it.
Yes.
Then let us talk about the relation between energy security and the Middle East.
Middle East aspect.
So where we talk about the important energy partners of India in Middle East, like the Saudi Arabia, UAE, Iraq is a very vital partner.
Kuwait.
Oman, Kuwait, where they're giving us crude oil and also LNG. Alright, so this is where we talk about this. And also a passing comment about other than energy security, Middle East is important for the safety of our diaspora, remittances, etc. Then coming about how do we integrate energy security with our foreign policy strategy, trajectory in the future years.
In the future.
First important thing is with the geopolitical risk that is there, again, diversifying our energy security is very important across different continents. We have Russia as a very important energy security partner, Latin American countries, where for African countries, which are providing us energy.
And maybe you can mention those facts that I think what they tell, more than 80%.
Yes, more than 85% of India's energy security is addressed through our imports, and more than, not now, but generally it was more than 70% was coming from West Asia, but only because of this Russia-Ukraine war, around 40% we are buying from Russia at the moment. Apart from this, we also talk about integrating this into our domestic policies, like focusing on strategic petroleum resources.
Correct.
India getting very subsidized oil right now, again focusing on strategic oil resource so that we can absorb any shocks due to geopolitical risk can be there, and also diversify the type of energy sources.
Correct. Not
LPG,
only crude oil,
LNG, and also you talk about green ammonia, green hydrogen is also very important. And we have one more thing you can add is talk about strategic minerals, especially we are moving towards electric energy. We'll need lithium, nickel, cobalt, which are important for our battery. So that is another dimension we can write. Also along with this, what we can write is talking about protecting the sea lanes of communication, which is very important. You see how Houthi rebels have become a very big headache in the Red Sea region. So protecting our sea lanes of communication for trade also plays a very important role. So all this together, I think we can write a
the China's, what is that famous?
The Belt and Road Initiative.
Belt and Road Initiative,
and talk about how India's IMEC is trying to counter this India, Middle East, Europe economic corridor, which can act as a safe corridor for India's energy security also. Because again, right now I believe another 2 to 3 decades we will be dependent on oil imports, although it is reducing.
Fine. I think broadly if you link that, you can be easily able to generate the demand, address the demand of the question. Then I think it's kind of very favorite and very often repeated topic. Reform process in United Nations remain unresolved. Unresolved is a keyword because of the imbalance of East and West, entanglement of US versus Russia-China alliance. Critically examine and critically evaluate East-West policy confrontation in this regard. I think they have made it, they have linked too many keywords here, but the core issue is UN reforms.
And again here, please don't fall for this, because if you want to write only East-West policy confrontation, your answer will be over in probably 1.5 days. So largely talk about United Nations, the role of United Nations or UNSC reform, UNSC, because it plays a very important role in maintaining peace and economic development across the world. Apart from this, then you talk about unresolved UN reforms. We'll talk about the need for UNSC reforms. If you see the current Security Council, it is a highly skewed platform in favor of the Western countries. Geographically also not representative, especially the global south does not have any representation. That is what we call as the East. So here, and we talk about the reasons why we are not able to have reforms. One is the procedural gridlock. It is a very big procedural challenge. The second one is the membership, who want to become the members or who are supposed to become the members. That is another issue, because again, if you ask Russia and China, for example, China proposes the name of Pakistan for UNSC membership. So lack of consensus amongst the membership. And also another important issue is the veto reforms. That is where again the East and West debate comes in, and the Western countries are not ready to give up their veto powers. In fact, 2024 was the year where the largest veto was used after 1986. So this is another fact that we are going to talk about. And again, should we give membership to Africa? If yes, how many seats? And why do you need to give UNSC membership to 3 European countries, or you can 4 if you consider Russia also? So all this is a biggest challenge. And also you talk about the impact of this East-West confrontation that has affected the world. Inability to prevent wars like the Russia-Ukraine war or the Israel-Palestine war. Talk about the Myanmar crisis, the contemporary challenges like cybercrime, or for example, the refugee crisis, which unfortunately United Nations has not been able to solve, thereby leading to a question of crisis of legitimacy for what we call as the global government. So here again, how are we going to conclude? Again, talk about few reforms that can be done. Try to bring in democratize institutions of global governance, give representation to countries like India, South Africa, and also Latin American countries. So this can go on and
Maybe
also,
that keyword of US versus Russia, that also they could have.
addressing the divide. The main reason for the failure of UNSC is because of the division of UNSC into two blocks. One block led by Russia and China, and the other block led by USA and its European partners. So this has to be addressed, even though it is a very big challenge, and the UNSC reforms are breaking this East-West confrontation is the need of the hour. If UNSC or United Nations can act as a platform to bring in peace and development across the world.
Yeah, very well addressed, sir.
All right.
Yeah.
So
This
again,
was-
if you observe, this is the 20 questions of
GS2.
GS2 paper, and I hope that we have been able to give you a broad idea and how structurally you can write these answers. Also, in the future, we'll be coming up with the same sessions for GS3 and GS4. At the same time, students can reach out to us for any preparation or any challenges they are facing regarding mains preparation, because as we discussed, it is very predictable. Mains is the easiest part compared to prelims, because prelims is very unpredictable. The syllabus says issues related to national and international
Very
importance.
vast,
But
very
here,
vast, very vague.
you can decode the syllabus and prepare accordingly.
Yeah.
So, and we wish all the students best of luck for those who are writing the remaining mains papers. And also the other students, we at Insights are open for guidance, and you can walk into our institution and seek guidance with us.
Yeah.
Good luck.